Okay, my name is Jennifer Brown. I'm an estate planning attorney. My office is based in Roseville. So as Lou said, I'm an Orangeville resident. I've been in the area my entire life. And I am passionate about this topic of estate planning, essentially wanting to make sure that the choices people make in terms of who they want to inherit their assets upon death, and more importantly, what happens if they become incapacitated while they're alive, who's going to take care of their affairs for them. So I'm here to talk to you guys about that today. So in talking about this concept of estate planning, I often tell people, think about it as like an umbrella. And underneath that umbrella, we have different documents that we put together to accomplish the objective, which is, again, A, getting assets from point A to point B, and B, to make sure that you're, oh yeah.
So solving our, let me figure out where I was. Okay, so we want to make sure that your ducks are in a row, bottom line, right? And so we accomplish that through certain paperwork. If you were to become incapacitated, even if you are married, it's not necessarily proper for your spouse to sign your name for you. They have to have legal authority to do that. It's not automatic. So this concept of estate planning is to put that framework in place, the legal documents in place that enable those of your choosing to take care of those actions on your behalf. There are a couple different ways that people can go about putting these documents in order, depending, and what we do will really depend on the nature and value of the assets that people own, as well as their family situation to some degree. If the rule of thumb in California is that if you have an asset that's worth more than $184,500, that's our probate threshold here. And I'm going to direct you guys, I put some brochures in the very front that has some of the information that I'm going to talk about today. But if you have an asset that's worth more than that probate threshold, you need to do some planning. So how do we dispose of assets? You can name a joint owner on the asset with you. So if you own a house with your spouse, you hold title as joint tenants with right of survivorship. If one spouse passes away, the other spouse, just by operation of law, will inherit that house. Same thing with bank accounts. If you pass away, the other owner on the account, if it's a spouse, a child, they will inherit that account by operation of law. So there's not a lot of extra planning that you might need to do in that case. If you have life insurance policies, 401ks, IRAs, if you name a beneficiary, when you pass away, that asset will go to that beneficiary. So you kind of have a little bit of a mini estate plan in place just by making those beneficiary designations. However, what if you're the only person on title for your house? Or maybe you have a spouse that has predeceased you and now you're the surviving spouse on title. At the time you pass away, now we have a problem because your house is likely over the probate threshold, which is $184,500. Pretty much anyone in California is going to meet that threshold if they own real estate. And we don't have any living person on title. If you're deceased, who is going to sell that property or transfer it to your intended heirs? Because a dead person can't sign a deed. So when that occurs, we have to go into probate. Has anybody here heard of probate or had to deal with probate before? It's not fun and it's very expensive. What probate is, it's the court process of overseeing the transfer of a deceased person's assets to get it out of the deceased person's name, paying the deceased person's creditors first, and then transferring whatever is left to the deceased person's heirs. Probate takes about a year, and the average cost of probate could be more than $10,000. It's very expensive. So avoiding it is key. Now, Does anybody have any questions, basic questions about probate or what was just mentioned? Does that make sense, what I'm saying about probate? Okay. So when a person comes in and we're looking at what type of documents are appropriate for them, the first thing we look to see is what type of assets do they have, and do they own real estate? If they own real estate and we have a danger of probate after their death, then we want to do some additional planning to prevent that. And that is where you hear about the revocable trust. The revocable trust is also a living trust, a family trust. They're all synonymous terms. But what the revocable trust does is it enables the house or other assets to get to your intended beneficiaries without probate. And how it works, I tell people, think of a living trust as like a bucket. You make this legal document. If you're married, both married partners will make the document together. And what the document says is that while you're alive, you are the beneficiary of your own trust, and you are in charge of your own trust. We call that person the trustee. So with this bucket, you own anything that's in this bucket, and you're in charge of the bucket. So you're in charge, you're holding the handle, think of that, okay? And then all of your assets, think of your assets like little rocks. The goal is we take your assets, your house, and we retitle it so it's owned by your trust. So that rock goes in the bucket. Same thing with bank accounts or life insurance. We can put whatever kind of rocks we want in the bucket, being mindful not to trigger any tax event. But while you're alive, your assets are in the name of your trust, you still own them, and you still control them because you're the trustee of your own trust. So if you decide to sell your house, you would sell it at escrow, and that rock comes out of the bucket to the buyer. You buy your new house, or maybe you just take the cash that you earned from the sale and you put it in an account. But wherever that lands in the name of the trust. So that money or that new house is in the name of the trust. Upon your death, the trust goes on to say who are the new beneficiaries. So that would be the person or people that you want to inherit your assets, children, whomever that may be. And then the trust will also say, now that you're deceased, who is in charge of that trust bucket. So that would be your successor trustee. So they come in and they're in charge of the handle, they're holding the handle, and then they take all the rocks out of the bucket and give it to your heirs that you've outlined in that trust. The trust allows us to establish the rules behind the distribution as well. So if you have minor children or grandchildren that you want to provide for who are too young to inherit right now, you can structure payments to them, you can reserve money for their education, and write in pretty much any type of provision you want. I like to say the sky's the limit, but you want to still be reasonable. But ultimately, that document allows you to have control over how you dispose of your assets after death. So that successor trustee will take those rocks out at the appropriate time and give them to the people that you designate. So the legal effect, using the house as the example, while you're alive, your house is in the name of your trust, you are the beneficiary of your own trust, and you are the trustee of your own trust. So nothing has changed with respect to your ownership status of your house. But after you pass away, the house is still in your trust, your successor trustee can sign for it, and then they have the instructions of who to give it to. So it becomes a very efficient and economic way to transfer assets after you die, in lieu of relying on probate court to do that for you. Does that make sense, how a trust works mechanically? Okay. So the trust is one component of this whole estate plan. So again, kind of going back to this umbrella, That's one document. In connection with the trust, we will also prepare what's called a pour-over will. A lot of people say, what's the difference between a trust and a will? I understand what you just said about a trust, but how is a will different? Think of a will as a document where you say, when I die, this is who gets it, and this is who's in charge. But that's where it stops. The trust builds in the mechanism to transfer your assets, whereas a will only says who gets it. So if we can't dispose of assets by beneficiary designation, say you make a will, you say this person gets my house, when you die, we still run into that same problem. Who signs the deed if you're dead? Where a will is important with a trust is if people forget to put their rocks in the bucket or something goes wrong, a pour-over will is designed to catch any rock that falls outside of the bucket and pour it into that bucket. So when we read a will, it says, well, who gets this asset here? And the will says, my trust inherits it. So it gets it into that bucket, and your trustee can then distribute it. So a trust and a pour-over will go together, like peanut butter and jelly. If you have a living trust made, you should also have a pour-over will made. And if you work with an attorney, it's like standard operating procedure that we do those two documents together. The pour-over will is different from just a regular old will, what we call a simple will, because the pour-over will go with a trust. A simple will, there's no trust. It just says who gets my stuff when I die. Does that make sense? Does anybody have any questions? The difference between a simple will and a pour-over will?
But you said with the simple will, that still goes through probate.
The question was, with a simple will, that still goes through probate? It's possible. So let me give you an example. If somebody was renting an apartment and they have their checking account, their 401k, and a car, they can dispose of their checking account and their 401k through beneficiary designations. Their car, because their car is going to be less than the probate threshold, that $184,500, will not go through probate. So in that example, a simple will is a completely appropriate estate planning document, because all of their assets can be disposed of without going through probate. Does that make sense, the difference between the two? So when somebody comes in and they say, okay, Jen, I have a house, I'm looking at a living trust option for them. If they say, I'm just renting, all my children are adults, it's pretty straightforward, then we'll look at a simple will. Because the simple will kind of covers everything else that's under $184,000. So it'd be mostly their personal items. Who gets the car, who gets grandma's dishes, those types of things. Yes, sir?
Is the $184,500 aggregate total or each item?
It is aggregate. That is a good question. So there's some wiggle room on that though, because if somebody says, well, I have a bank account with $100,000 in Chase, and I have a bank account with $100,000 in US Bank, technically that should be probate because it's aggregate. You add them together. However, most people don't probate that asset, and I'll get to that. There's an alternate little trick that we can implement to avoid probate circumstances like that. So, okay. So far we've got the trust, and the pour-over will, and then a simple will. Those are kind of the side of the umbrella in an estate plan that deals with what happens after you die in terms of disposing assets. The other goal that we look at is what happens if you become incapacitated. We don't ever want to think about that. That's the worst case scenario. But if you do become incapacitated, We want to make sure that you have a power of attorney lined up to take care of both financial transactions and medical decisions. So the whole concept of a power of attorney is basically, if I can't do something, I'm going to appoint this person over here as my agent to act on my behalf and do my bidding. So these powers of attorney, you are making that nomination, but oftentimes the power of attorney will not take effect or essentially be implemented until you are incapacitated. There are different kinds. If you are in a stage of life where you're having a child or somebody help you already right now pay bills, you can make that power of attorney effective immediately. So that really puts them on record in a legal way, so they can maybe perhaps talk to Chase without you to pay a bill or resolve a problem. But most people will do what's called a springing power of attorney, which means they make the power of attorney document right now, but it doesn't spring into action until a physician has determined them to be incapacitated. So we do two separate documents for this. The financial power of attorney takes care of, you got it, all of the financial transactions. So filing your taxes, calling Social Security, dealing with an IRA distribution, all of those types of functions that we do on a day-to-day basis we don't even really think about. But a random person cannot do them for us. They have to have authority. And then we also do a medical power of attorney. If you can't give informed consent about a medical decision, this document will nominate who talks to the doctor on your behalf and what your wishes are with respect to life support, if you're in a vegetative state, palliative care, organ donation, burial versus cremation, DNR, all of those things that we kind of don't like to think about, but it serves as a guide of your wishes to the person you choose, and then also gives them the authority to talk to the doctors in that regard. Without those legal documents in place, if you had an incapacitation, your family would have to seek remedy through the courts, through what's called a conservatorship. And that is horribly, horribly expensive. $5,000 up front to an attorney to just take the case to do a conservatorship. There are other workarounds. People can try to do it on their own, but it's a very cumbersome and confusing process. The conservatee has to get their own legal counsel because they need to be represented separately. It's the worst case scenario. So making a power of attorney, I think, is the most crucial estate planning document one can make. If you're dead, you're dead. People can fight over your stuff and wait their turn in line to get a crack at your assets if they have to go through probate. But if you have a stroke and your mortgage is due, your credit card is due, or someone needs to sign the form and the doctor, you're alive. And that's a critical time. And so you want to have those documents in place at a minimum to make sure that you're protected. Trust, will, financial power of attorney, medical power of attorney. Those are the meat and potatoes of a estate plan. Or will, financial power of attorney, medical power of attorney, depending on the type of assets a person has. Before I go into how you can go about putting these documents in order and where you can get information, does anybody have any questions about the legal documents that I just described? Yes?
What's the difference between medical power of attorney and advanced healthcare directive?
The question is, what's the difference between a medical power of attorney and an advanced healthcare directive? They are the same. So when you look into this area, there's a lot of terminology involved, which can add to the confusion about having these documents in order. So a medical power of attorney is the same thing as an advanced healthcare directive, which is also the same thing as a living will. Well, that's confusing because you've got a will to dispose of your assets and then a living will? What the heck? But they are the same. Now, taking it one step further, the advanced healthcare directive is different than what we call the POLST, which is a physician's order for life-sustaining treatment. It's the pink one. Do any of you guys have a POLST, the pink one? Does this look familiar to anybody? So everybody should have a advanced healthcare directive. This POLST is a form that is created between a patient and their doctor and is generally recommended, I have it upside down, generally recommended for people who are either advanced in age or have some type of end-stage illness. This is designed to live on the refrigerator of your residence, so when first responders come into a home, they know what type of medical attention you desire to have. If you are advanced in age but are healthy and you have a heart attack mowing the lawn, yes, resuscitate you. That's what you want. But if you're advanced in age, have stage 4 cancer, and had a stroke, don't resuscitate you. Whatever your wish is. First responders are required to provide medical attention when they come into the residence. My paralegal, her father, who was an estate planning attorney, ironically enough, had advanced dementia and was living at her home with her. And he had a cardiac event, and first responders had to provide CPR for 10 minutes on him while they watched. And he did not want that because he did not have a pulse, and they could not find his medical directive. So this is something you can get from your doctor. I do have some forms here with me today, but they're not pink. I just made the photocopy of them. But the first responders will look for those on the refrigerator. So those are kind of the medical related documents. Does anybody have any questions about, any more questions aside from Monty about the documents themselves before I provide some resources for you on how to go about it? Yes?
Is that advanced healthcare directive, is that part of the living trust, or is that, with Kaiser, we get a separate pamphlet that's that advanced healthcare directive. So do we need both, or how does that work?
The question is if the advanced healthcare directive is part of the living trust. Kaiser provides a directive for their patients to use. So that is, in a sense, kind of the next thing I was going to talk about. So it's perfectly timed. So when you have documents drawn up, there's a lot of different ways you can go about doing that. It is very common when people work with attorneys for this process that we will package all of these documents together. So, for example, when somebody comes to see me to have an estate plan done, for a flat fee, I will put together their trust, their pour-over will, their financial power of attorney, medical power of attorney. If they're a PERS, if they have PERS because they work for the state, we'll do a PERS power of attorney. We'll do a HIPAA waiver. We'll do instructions for disposition of their remains. We'll do lists about how they want their personal property disposed of. So it's a very comprehensive process that people go through when they come and work with me to do an estate plan. And that's very customary with a lot of attorneys. It's a nice suite of documents. I call it the legal toolkit, right? But for folks who don't choose to work with an attorney, they can get a free medical directive from their doctor. Oftentimes, I know Kaiser offers them to their patients. I believe Sutter has it. And you can get, and I have this to hand out, you can download them from the internet. Sacramento County Public Law Library has a free statutory power of attorney, a free statutory medical directive, and a free statutory will. What does that mean when I say statutory? That means that the legislature has decided and codified these documents. So they're very basic. Think of them as like the attorney created estate plan is the Cadillac that's going to get you from A to B. These are kind of like the Honda Civic. They're still going to get you there. They're still going to do their job, but they don't come with the bells and whistles. So if price point is a major factor for people, or maybe they have a very simple situation and they don't really need a big, hefty estate plan, then the free option is a good option as well. So if you have the document from Kaiser, fill it out, put it on file with them. If a client has a Kaiser directive, they come to me, I will ask them, do you plan to stay with Kaiser indefinitely? Because the Kaiser directive is only good at Kaiser. Or we can do a universal one that's accepted anywhere. So if you plan to change networks, or if you're going to have an out-of-network procedure, it's good anywhere. Did that answer your question?
If you have one in a living trust, how does Kaiser get that?
It's not. The trust is a separate document. So that umbrella, all of these things I'm talking about are their own separate standalone legal document. So if I create a medical directive in my living trust plan for my client, I give them a copy of their medical directive and say, put this on file with Kaiser. You can upload it on the website if you use their online user face, or they have a little drop box right across from the lab. Member services, you write your member number on it, put it in the box, and they'll scan it. Yes?
Would you go over again, you had kind of like some parameters of when a person would be advised to be resuscitated and when not?
So that is, the question is for me to go over some parameters when somebody would request to be resuscitated or not be resuscitated. That's actually more of a question perhaps that you would want to raise with your treating physician, because that is really dependent on what a person's own medical status is. I work with a lot of different people with many situations, healthy, sick, old, young, and that's really a personal decision, and I do find that it's all across the board. I do have some clients that say, I'm going to appoint this person as my agent, and I'm going to put 100% of the decision in their hands because I don't know what the circumstances will be at the time this document is used. So I want them to make that decision in real time as to whether I'm resuscitated or on life support. But if you have a medical situation or something, that I think that would be an appropriate decision to have with your treating physician. Yes?
If for any reason someone had a power of attorney and let's say that person did pass away or for whatever reason that needed to be changed, does a new power of attorney need to be documented, or can you make a change just with a notary? Is there a form to do that, or do you need to go back to the lawyer?
So power of attorney, did everybody hear the question? Okay, so power of attorney is only legally valid when you are alive. So if you are alive, your power of attorney that you made is valid, even if you're incapacitated. And I'm going to say that with a caveat, because there are some powers of attorney that are used for a very narrow purpose and are only under certain circumstances. But most powers of attorney are what we call a general, durable power of attorney, which means its duration continues to go even though you're incapacitated. So long as you are of sound mind, you can revoke your power of attorney, change your power of attorney, redo it, whatever you need to do. Once a person is incapacitated, that power of attorney can no longer be changed because they're not lucid to make the change. They have to understand what they're signing. When a person dies, the power of attorney becomes void. So if you have a bank account and your child is your power of attorney on your bank account and you die, they will lose access to that account. The power of attorney does not survive death. When a person dies, everything will revert over to either their trust or their will, kind of on that side of the umbrella, the death side. You've got the incapacity side and the death side. Did that answer your question?
Partially. I guess my specific thing is if you're still alive and for some reason you needed to change your power of attorney person, do you need to go to the lawyer to have that done, or can you just have it notarized?
You can have a new one notarized. You don't have to go back.
There's a form somewhere for that?
Yes,
Okay.
and so you can get a free form, which I did bring many copies of the statutory power of attorney with me today. So if you guys wanted to take one and look at it or take it and fill it out, if you don't have one, at a minimum, do that. It does require your signature to be notarized. But one thing I will say is if people choose to work with an attorney, maybe they own real estate, or maybe they have complex family dynamic, or maybe their heirs are minors. So you put your grandchild or your child on a bank account and they're not 18, they cannot legally take custody of that money. And that is going to trigger a legal problem that's going to require court intervention. So if people have minor beneficiaries, the trust becomes a very economical way to dispose of assets for the benefit of minors. But going back to the question, can you just do a new one? Sure, you can absolutely do a new one. If you worked with an attorney before, you don't have to go back to that same person. I always tell people I prefer to have a longevity in the relationship with my clients. Because if I have a client that has worked with me for 10 or 15 years and right before they died, we now have a statutory power of attorney that's done by a different child in the 11th hour and assets changed. Okay, that's ripe. That's ripe for proving undue influence or some type of malintent. And so if you work with somebody who gets to know you, your family, and you maintain continuity of the relationship, then you do have a resource that can help you through life's transitions, whether it's a child who's made bad decisions and has drug abuse problems or creditor issues, or it's time to bring on a kid to help with managing finances. And if you work with somebody who knows you, they can help determine and make sure that you're not being unfairly taken advantage of or unduly influenced by the choice that you're putting before them. So there's a lot of advantages, I think, to working with a professional.
So what do you recommend for naming a beneficiary, the trust as a beneficiary? So life insurance, bank accounts, what about 401k?
The question is, how would I recommend naming the trust as a beneficiary on certain assets? So we're going to use that rocks in the bucket analogy again. Okay. So depending on the goal of disposing of assets and who the intended beneficiaries are, I will custom tailor what needs to be in that trust and what can be disposed of outside of the trust. It is very rare to recommend that certain retirement accounts go into the trust. So you hear this term retirement accounts. What does that mean? You have two different types of retirement accounts. You have what we call your pre-tax, or tax qualified is the legal term. I call them the alphabet soup accounts. 401k, IRA, 403b, HSA, all of those acronyms are referencing tax code on the rules of how you take that money. If an account has an acronym, an alphabet soup account, we don't recommend putting it into the trust. Because that's going to trigger some, or could potentially trigger some negative tax consequences upon death. Without getting into the legal weeds, trusts have different tax brackets than people, which is less favorable. But if I have a client whose kids are minors and they've got their 401k, then we have to get creative. There's some provisions we put in the trust to account for mitigating potential tax ramifications. But putting life insurance into a trust, spouse is primary beneficiary, trust is contingent beneficiary, bank accounts, brokerage accounts, so your after-tax dollars that you then invest in the market, either a mutual fund or a stock, those can go into trusts. Depending on annuity proceeds, annuities are kind of a tricky one, they're a case-by-case basis. But if I have adult children and we're not needing to hold money and maybe we want some quick cash to the kids, then naming kids as beneficiaries on life insurance. It really just depends on each person's design of how they want to transfer money and when and for what purpose. Did that answer your question? Okay. Yes, ma'am.
Back to the power of attorneys, financial and medical. I thought that's who we were to name to be in charge of the trust, both when we're incapacitated and after we die. They're in charge of making sure the trust gets done as it's supposed to be done. But just recently you said that once we die, there's no more power of attorney. They're not in charge anymore. So I thought they were in charge. I thought that's why we named them.
So there's different situations under which those documents apply to. So a power of attorney, they can only deal with either medical decisions or financial decisions while you're alive. When you die, you're dead. So they don't need to, those documents don't apply to decisions about your, I'll get to your, I'm going to answer your question. They don't apply there. When you die, you're not filing a tax return, years after you die. So there's not transactions that deal with that. The trust, when you die, that's where those transactions pertain to, the trust and the will. But during incapacity, let me give you an example. So if you have a house and that rock is in the bucket, in the trust, so the house is in the trust, okay? The trustee of your trust will be in charge of that house. If you have the same person as the trustee of your trust, and they're also the same person that you designate as your financial power of attorney, when you're incapacitated, say you're in a nursing home, and it's time to file your tax return, under the power of attorney, they'll use their authority under that document to file your tax return. But if there's a problem with the house, they'll use their authority under the trust to deal with it, because that asset is part of the trust. So there's overlap between those two documents while you're alive. But when you die and this power of attorney terminates, your final tax return, so you die in February and your taxes are due in April from last year, the executor of your will is in charge of that. So they wear different hats for their different jobs depending on what the situation is. So it's very common when trustee and agent selection, when you make an estate plan, is extremely important. So when I sit with a client, I'll say, okay, you want your kid who lives in Virginia to be your trustee and your financial power of attorney agent, because they're with it, they've got a good job, they're organized, they're trustworthy, great. You bank with Bank of America, they have branches on the East Coast, you're good. But if you break your arm or fall off a ladder at the house here in California, are they the best person to take you to the doctor or talk to the doctor if you conk your head when they're across the country? Maybe we choose the kid who's here, who's loving, terrible with money, but they're gonna take you to the doctor. So it's lining up those decisions of who's gonna do what and who's gonna wear the hat. Does that make sense? Did that answer your question? Okay. So you can see we just like scratched the surface, like one little scrape on the lotto ticket here. There's a lot of thought that goes into putting these documents together, and you don't know what you don't know. So a lot of people choose to work with a professional because of that. All right, so what type of professional? There's kind of 3 different ways you can go about putting these documents in order. Of course, you've got the do-it-yourself option, which is, for people who have a really simple situation and they're comfortable with legal documents, it's not a bad deal. Especially if cost is a factor. So you've got the free will, power of attorney, medical directive from the law library. So you can go that route. There's a middle route, which is in California, we call them legal document preparers. They're non-attorneys, and they will put these documents together based on how somebody tells them they want them. So you fill out a form and you say, I'm going to name these people, and they just prepare the document. That's it. They are not lawyers. They're not permitted to give legal advice or make suggestions on what you should do. So again, in some circumstances, a legal document preparer might not be a bad route to go, again, if cost is a factor. But I will tell you, I have gone to court and had to fix a lot of errors made by legal document preparers. Or I've had to probate estates because somebody thought they had documents in order that they had done by a legal document preparer, and they were not properly executed. So it is risky. I always say, not always, I say that all the time. If I'm gonna change, if my brakes on my car need to be changed, am I gonna roll up a YouTube video and do that by myself in my driveway? Heck no. I'm not gonna do that, because that's a critical thing. So I'm gonna pay a professional to do it. Okay, and then you do have the professional, you have the attorney. And even within the attorney sphere, you have a lot of different variation. You have what they'll call a trust mill. You go in, you pay your $1,299, and you get your estate plan. Maybe you talk to an attorney once, and then you have to pay for your own notary. You have to go record your own deed to get your house in the trust. And again, if cost is a factor, maybe not a bad way to go if you don't have family dynamic. If you have family dynamic, work with somebody who's going to give you the time and attention to talk to you about your family dynamic. They should be meeting with you at a minimum twice, if not 3 times, to talk about those factors. They should be going over the design of the plan. They should be sending you drafts to review to get your feedback, talking with you, answering your questions if you don't know what the terminology means. So then you do have, a variety. So you've got the kind of the trust mill, and then you've got the attorney who's on Capitol Mall that you're paying $5,000 plus for your trust because you're paying for the fancy stuff. I'm not there. I'm kind of in the middle ground. I take the time with my clients. I'm not the cheapest out there. I'm not the most expensive out there, but I try to have a continuity in relationships with my clients and give them the time they need so they understand what these documents are, how often they should review them, who should get copies, how to execute on the instructions that I give, and then also to know that they have a resource to call if they have questions or forget what I told them. So You can expect within this region for an estate plan, if you need a full living trust estate plan, that is, to spend for a single person somewhere around north of $200 or $2,000, sorry, and probably shy of $3,000, somewhere in the $2,000 to $3,000 range. And if you're a married couple, maybe somewhere between $2,500 and $4,000, just depending on who you work with. And it's very common that that is a flat fee model, which it will include your meetings, your drafting, notarization, recording. If you find somebody who is charging a lesser rate, ask questions. Does this include notarization? Does this include you recording my deed, or do I have to do that? So do your fact finding, shop your attorney, make sure you feel comfortable with them, make sure you feel like they're giving you the time that you deserve if you're gonna go that route. Because it's an investment, but it is also one of the greatest gifts that you can give your family by leaving those instructions when they're done well, because it makes it a heck of a lot easier for them to help you. Yes, ma'am.
What is the cost of amending a trust?
That's a good question. What is the cost of amending a trust? So it will depend if you go back to the attorney that helped you, if you had your documents done by an attorney, or if you go to a different attorney. So these documents are complicated, and if somebody comes to me with another attorney's work product, if I touch that attorney's work product, it's like the hot potato. I am responsible for it. So if there's a problem and there's a lawsuit, I'm the last one that touched it, I'm getting sued. So it's very unusual for attorneys to amend another attorney's work product, because then we adopt responsibility for it. So if you go to a different attorney, you can expect to do what's called a restatement, a redo of everything, which is going to cost probably closer to what you paid for the whole dang plan in the first place. If you go back to the attorney that helped you, it's very likely, like in my case, I will just do an hourly arrangement with my client. So they only pay for the time they need, and I have a couple of paralegals, and they will do the drafting. They're the workhorses, so their time is less expensive. And then my time is limited to reviewing documents or meeting with my client if they need legal advice about the change they're making. And then I'll step in and say hi on the day that I don't charge them for that though, that's just a social visit. So it becomes more economic, I believe, if you stay and have continuity with a practitioner if you choose to work with them.
So I'm a little confused about how you would go about finding this type of attorney. I mean, we're here in this setting, and we are hearing your position, which is very helpful. Mm-hmm. But if I'm outside and I cannot have any contact, I'm looking in the newspaper or the internet, and it says, somebody.
How do you choose? Yeah, that's a good question. And I know I'm probably coming up on my time here, but I think a referral is always a wonderful way to find a professional. Whether you're getting a referral for your plumber, a referral for a financial advisor, or a lawyer, that tends to be a really good way to find somebody to help. You can also call your local bar association, because I'm on the board of the Placer County Estate Planning section of the bar. We maintain a list of all the practitioners who subscribe to our section, who are in good standing, who keep up with the legal education requirements to still be competent to practice. So that's a good way. But I think sometimes what you miss out is maybe, is this person good with my personality? Do I feel comfortable? So if you're relying on another trusted friend or professional to say, well, who do you recommend? Who do you work well with? I know with Luz and I, when we collaborate and we have mutual clients, after I complete the estate plan, I reach out to her, I'm like, okay, this is what I told them, I want this account this way, da-di-da-di-da. She whips up the documents, they come in and sign, and between the two of us, we help the client with, keeping on the straight and narrow. So if you have a financial advisor or a trusted professional, asking them, a lot of attorneys, for me, I do a complimentary consult for people who don't have an estate plan in place, to have the conversation with them that I've been having with you guys today. That gives them also an opportunity to see if it would be a good fit for them. Some attorneys do charge consult fees. For me, if somebody has an existing estate plan that I have to spend my time to review, perform a legal analysis, and then meet with them to render my legal analysis, I do charge for that. I do charge my out is a $350 charge. And sometimes free advice is not great advice. You want somebody who's going to take the time and actually give you an analysis. So,
along those same lines, my husband and I have had our will done twice, about years ago, and it was my impression, you go into the office, you fill out the forms, you talk to them, they sign it, it's legal. And then you don't talk to the person again. So I'm having a hard time relating to what you're saying. You keep in touch.
Well, I don't, I
in a drawer.
Yeah.
It's fun.
Part of the advice that I give my clients when we finish the plan, I say, do you use a calendar? Put on your calendar 2 years from now, or 1 year from now, or 5 years from now, to pull out the estate plan and look at these 3 pages. Call me if there's a change. Call me if there's a question. I do not have the time resources to call and reach out to every single client that I've assisted throughout my career. I love when I see them and I call them if I recognize them out in public, right? But I can remember a name, but remembering a face is a challenge for me. So it really becomes the impetus of the client to reach out when they have a changed circumstance. But that is part of what I coach them on when we finalize documents. What would necessitate that kind of call, or so.
So we are. I do want to get to our break time.
Yeah.
Do you have anything else to say? And I want to share a few.
So I'm going to put in the back. So during the refreshment period, this resource that shows you where you can download free forms if you don't have one. I've got a few copies of a free advanced healthcare directive, a few copies of free powers of attorney. So if you don't have anything, maybe grab those on the way out the door. And I do have, again, the brochure and my business card. So if you feel that you would want to have an individualized conversation about your circumstances, please feel free to call my office and my staff can schedule an appointment.